Hello, welcome to SENDIST Camden Tribunal Training for Parents webinar. This is a very simple webinar that should take you through the process of applying for tribunal and what happens once you apply for it. Our take-home message is to stay strong. This is a very, very stressful thing you're about to undertake. However, it pales in comparison to some of the stresses that you may have felt along the way. That means that that's why you're ending up considering going to tribunal. So stay strong and don't give up. So this is broken down into two parts. Part one is everything about tribunal before you appeal, and part two is what you do once you have decided you're going to appeal. So what is the SEND Tribunal? There's a few different names for all this. Tribunal, SENDIST, First Tier Tribunal. There's a few different names, as it says, but it all refers to the same thing. So what is tribunal? The First Tier Tribunal, Special Educational Needs and Disability, is an independent national tribunal which hears parents and young people's appeals against local authority decisions about the special educational needs of children and young people. It can also hear the claims of disability discrimination against schools, colleges and local authorities. Disability discrimination is if someone is treated unfairly because of their disability or because of something arising from their disability. All of this may be disability discrimination. Claims of disability discrimination can be brought against public bodies such as early years settings, schools, colleges, and local authorities. This would be a separate case from appealing against decisions by the local authority. The SEND Tribunal is governed by the law and has to follow the interpretation of that law by higher courts in judgments about previous SEN disputes. The SEND Tribunal must have regard to the SEN and Disability Code of Practice, known as the Code, which advises schools and local authorities on identifying and making provision for children with SEN. The SEND Tribunal is not bound to follow the Code to the letter, but it generally accepts the Code's guidance in coming to its decisions. Please note that this reference is to the law and not local policy. Sometimes these are not in alignment. And finally, the SEND Tribunal looks at the evidence put before it and decides whether the LA decision followed the law and the code. It will make a decision based on what is right for the child or young person at the date of the hearing. Now, the SEND Tribunal has the power to order local authorities to carry out education, health and care needs assessments, issue education, health and care plans, and amend existing education, health and care plans. Local authorities must comply with the orders made by the SEND Tribunal. So, should I appeal? Well, this is a judgment call that only you can make. Do you feel that the local authority have made an informed decision about your child? Do you feel that the school will be able to use the plan to help your child's education? So when can I appeal? You can appeal if the local authority refuses to carry out an education and healthcare needs assessment or reassessment. If the local authority refuses to issue an education, health and care plan. If the local authority issues or amends a plan, but you disagree with any of or all of Section B, Special Educational Needs, Section F, Special Educational Provision, or Section I, Placement. Or if the local authority decides not to amend an education, health and care plan after an annual review. Now, if that does happen, the local authority must continue to provide what is in the plan until after any challenge to the decision to cease. That's actually more relevant to that point. The local authority decides to cease to maintain. So how to submit an appeal? You should have been sent a letter from the local authority when they took the relevant decision or issued you with the final education, health and care plan. This letter should contain the following information on your rights of appeal. Your right to appeal the decision, the time limits for doing so, information about mediation, the availability of disagreement resolution services, and information and advice about matters relating to the special educational needs of children and young people. So this letter is the key to unlocking the next steps that you may want to take. I myself have thrown out the letter when it's arrived at my house for my child in a fit of rage, and then I've come to regret it later. The letter is the key. You have to show a copy of it when you want to lodge your appeal to say that this is now the stage that you're at. The SEND Tribunal may extend your deadline if all of this information was not provided and the deadline has passed. So who can make the appeal? To be able to appeal, you must be a parent or a young person over the age of 16. In education law, parent means that you are either a birth parent, you have acquired parental responsibility, or have care of the child, for example, a foster parent or grandparent with whom the child lives. If the decision concerns a child under the age of 16, it is the parent who has the right of appeal. If the decision concerns a young person over 16, then it is the young person who has the right of appeal. And you need to see, we'll come to the section of young people and their rights for more information. If a young person cannot bring appeal themselves, because making an appeal, if a young person can't bring an appeal themselves, you can make an appeal as an alternative person. If a young person does not have the mental capacity to bring an appeal or to make an appeal or to make decisions about the appeal, then it can be brought by an alternative person acting in the best interests of the young person. This will be any deputy appointed by the Court of Protection, or if this has not happened, then usually a young person's parents. You could also be a family member or someone from the local authority's social care team. It's also worth noting that it's free. Appealing to SEND Tribunal is free. There are no fees for parents or young people to pay. So, mediation. In most cases, you'll need a mediation certificate before you can appeal, and you can get this in two ways. You can undertake mediation, and if it doesn't settle all of the points in dispute, you'll be issued with a certificate confirming you took part in the mediation. You can speak to a mediation advisor and you'll be issued with a certificate confirming that you've been told about your right to mediate, but you do not want to do so. If you're appealing only about the school or college placement, or where no school or college is named, you do not need to attend mediation or acquire a mediation certificate. So mediation isn't compulsory, but it must be considered. It's worth noting that mediation is a less formal way of trying to settle a dispute between you and the local authority. If you've never had a proper discussion with the local authority about why they've reached their decision, mediation may help. You might also consider it to give yourself more time to appeal. The deadline for requesting mediation is 2 months from the date of the decision letter, or 1 month from the date of a mediation certificate is issued, whichever one is later. And obviously that's a very good reason why you need to take note of the letter that's issued to you by the local authority once they've made a decision that you want to challenge, because that is the key that sets out the time frame that you have to work within. So mediation outcomes. The next few slides contain a fair amount of legal timescales. It may seem confusing to hear them all at once, but once you have an idea about your own case, they may appear more straightforward. It's important that you know these, as it may be important in your case if the LA does not stick to them. So to carry out an education, health and care needs assessment, the local authority must notify the parent or young person it's starting within 2 weeks, then either let the parent or young person know they've decided not to issue the plan within 10 weeks. It's probably worth your while just to come back to these timescales later when you know what it is that you're looking at appealing, and find the timescale that actually applies in yours and your child's case. So The decision letter, so important. I'm repeating this slide again. The decision letter, you should have received a letter from the local authority when they took the relevant decision or issued you with the final education, health and care plan. This letter should contain the following information: your right to appeal, the time limits for doing so, information about mediation, and the availability of disagreement resolution services, and information and advice about matters relating to the special educational needs of children and young people. And remember, the SEND Tribunal may well extend the deadline if all this information was not provided. So if you didn't get the letter and you've missed your deadline, you can still register an appeal. Can I get help to appeal? So the Tribunal service has set itself up to be parent and young people friendly, so it's not necessary to have representation, and many parents and young people are happy to undertake this without additional expense and support. But if you qualify for legal aid, you can get help to prepare your case, although not representation on the day of the hearing. Some people choose to pay for an advocate or specialist lawyer to help. In some cases, Camden SENDIST officers can support you with your queries about Tribunal. However, we're not able to represent you in court like a solicitor can. If you qualify for legal aid, we can answer your questions and provide support until your case is allocated to a solicitor. There's now a short film about Tribunal.
I didn't know quite what to expect going there. I was hopeful that we'd get some justice, but I didn't know what to expect.
I expected it to be very formal, very legalistic. I thought it would be difficult for me to get my ideas across about what I want to say about my child.
I suppose the things that I dreaded most was that the other agencies would have a stronger case than I did.
I thought that the local authority would have more time to speak, that they would be more professional in their approach than I could have been.
We'd been a bit frightened about standing up against the local authority, but in that hearing I felt put on a level footing with them.
Those of us that go to Tribunal representing the local authority are well experienced in matters of special needs. We go to Tribunal with a view about what we feel is probably the most appropriate and adequate education that we can be making for a young person.
You have obviously the local authority there expressing a very different view to yourself, and emotions can potentially run high.
I held up quite well on the day. After I'd finished the whole thing and we left the room, then I got really emotional because that was the end of the whole case and I could kind of relax and let go of it.
They do try and make it as informal as possible, but obviously at the end of the day one has to be minded that you are working within legislation. You can't go outside of that.
What I felt was the Tribunal panel were very good at putting us back at ease and making us feel comfortable that we were getting a fair hearing.
I didn't get upset on the day because the actual Tribunal was to decide for my grandson, and my daughter, I had her with me, so I couldn't get upset. I was too busy fighting my corner.
I hoped I was going to get a fair hearing because it had been frustrating trying to get the local authority to listen.
Certainly you need to continue to have a dialogue with parents. That's paramount. It's essential to try and continue that dialogue, even if parents are not willing to do that. Often we get into a situation where parents won't speak directly to us, which may well be able to resolve the problems before getting to a hearing. We would all like to try and resolve issues at a more local level if we can, and hopefully then come to an agreed way forward rather than having to use this formal process.
I would very much advise other parents to consider going to Tribunal if they feel that they're not getting anywhere with the process of creating a statement.
There's so much to gain in going to Tribunal that even if you are not a strong public speaker or you are not terribly au fait with with all the procedures. I think you should still go for it, but you should try and go with a realistic attitude to make sure that you know your case inside out, that you're not afraid of speaking out and saying exactly what you want to say on the day, because you won't have another opportunity of doing that.
You have to speak up, you have to make yourself heard, because it's important, it's very important.
It's worth the heartache and the paperwork and the effort, because you do get the feeling that you get fair play and justice.
It's something that if you feel it needs to be done, then you have to do it.
So how do I register an appeal? You'll need to fill out specific official forms depending on what you're appealing. SEND 35 is for all education, health and care plan appeals, apart from SEND 35A, which is for refusal to assess. SEND 28 or 28A are forms for children in youth custody, and you have to send in all supporting evidence to the SEND Tribunal. Remember to keep copies of all your paperwork, letters, reports, etc., so you have a clear record of everything you've sent. You can submit your appeal either by email or by post. If you send it by post, we recommend you send it recorded delivery. SENDIST prefers everything by email if possible. So the appeal form. You can obtain the form from the SEND Tribunal's website. In the boxes on the appeal form, fill in your child's name, date of birth, or yours if you're a young person, your name and address, details of anyone else who has parental responsibility, if possible, the name of your LA and the date of the decision you're appealing against, or the date of the final education, health and care plan, any special requirements to make the process accessible to you. Say here, if for instance you need documents translated, you need wheelchair access, a reader or a signer, or cannot manage negotiations over the phone. So in the appropriate section of the form, you'll need to explain which decision you're appealing against or which part of the education, health and care plan you disagree with. This is called your reasons for appeal. You don't need to write a long answer or write in legal language, but you do need to say clearly what you're appealing against and what you want the tribunal to do. Think carefully about your reasons for appeal, because it may be difficult to change them later on. I find that writing in a small box constrains my thought process. So I like to write it all out in longhand first, and then I find it easier to write it in. If no assessments have been carried out, such as an EP or SALT, and you think they are necessary, say so. The tribunal has the power to order the local authority to conduct assessments. And as much as possible, you should try to get together any supporting evidence to submit your appeal. Don't worry if you don't have everything to send straight away. You can always submit more evidence after you've registered your appeal. But you must send in enough information for the local authority to be able to respond. So do's and don'ts. Do keep it short and to the point. Do separate your points into paragraphs. It makes it much easier for people to understand and to see the point you're making. Do number your paragraphs or organise them under headings. Do refer to any evidence that backs up your points. You can send more evidence later, and you should say if you know there is evidence you don't yet have but intend to send later. And refer to the legal issues that you know of. Don't get bogged down on history. If there's a long history of difficulties between you and the LA, let the evidence, for example, letters between you and the local authority, speak for itself. So what should I send with the form? With the completed and signed form, send the SEND Tribunal the following: A copy of the letter the local authority sent you that told you of its decision. This is the letter I've referred to a few times now. Your mediation certificate, the evidence supporting your arguments, and a list of all the documents enclosed with the application. It will be helpful to the SEND Tribunal if you put your evidence in chronological order and then write out a list explaining what each document is. Don't send original documents, send photocopies or scans. Keep a copy of everything you send, including the form. So if it's a late appeal or you have no mediation certificate, SENDIST can be surprisingly amenable if there's a good reason for an out-of-time appeal. Examples we know of are parent is dyslexic and didn't know what the local authority's decision letter meant, only understanding the implications when she showed it to school who made the request. Local authority decision following mediation was after the stated deadlines, or the letter from the local authority was unclear about whether assessment was going ahead or not. The letter from the local authority did not set out the right to appeal. So here's just an example of if you're sending things by email, how to actually send it and to log it down. So you can see you put email 1 of 6 and then you're listing all the attachments here that are then attached across the top. It's a time-consuming and fiddly job, but it does have to be done. The list of documents you send should match the checklist in section 8 and list of documents in section 11 of the form. So when the appeal is registered, it will take 10 working days from when they receive it. SEND Tribunal will tell you the appeal has been registered and the date of the final hearing of the appeal. The appeal number should be used whenever you contact SEND Tribunal about your appeal. You have to read this carefully when it arrives. There's a list of all the important dates. Once it's registered, you'll get the letter with case directions, an attendance form and a case management questionnaire. The directions will set dates by which you must take action and send the local authority and SEND Tribunal information which will be considered at the hearing. It will also set a date by which you need to tell the local authority and SEND Tribunal about the witnesses, if any, that you'll be bringing and anyone else you want to come to the hearing. The local authority will also be sent the appeal paperwork at the same time, and this may be the first they know of your appeal. So the local authority response, once they receive notification, the local authority has 30 working days after they receive the appeal to respond. The actual date will be in the registration letter, so the courts will tell them the date they must respond by. At this stage, they will state the reasons they oppose the appeal or inform all the parties they do not oppose the appeal. If they do not oppose a refusal to assess appeal, the appeal will automatically finish and the local authority must write to the young person parent within 4 weeks to say it will carry out an assessment. Additional evidence. You can send additional evidence at any point from the date your appeal is registered up until the deadline set by SENDIST, listed in the registration letter and in the key dates timetable. That's why you need to read letters and documents and write down the key dates in your diary. Ask yourself if you want anything else sent to the tribunal. You can get help to identify and obtain information you feel would assist the case. Look critically at the evidence sent with the appeal. Are there any gaps? For example, an educational psychologist mentions a dyslexia assessment, but this is not in the appeal paperwork. School have not sent a provision map, even though the child gets SEN support. If evidence needs to be sent after the deadline, you'll have to request permission to do this and follow these steps. Send the evidence to the local authority and ask for their response. Once you have their response, whether it is or if you don't have it but they have taken too long to answer, email a request for change form, which is available on the SENDIST website, and you attach a local authority's response or lack of it and the evidence to SENDIST. You will receive a tribunal order at some point accepting this. Appeal ending before the hearing. If either the local authority you decide to end the appeal after the local authority response has been sent and before the hearing dates, SENDIST needs to be formally informed. This happens either by the parent formally withdrawing their appeal using Send 8 form or by a consent order signed by both parties. So nothing has been withdrawn, you're going to go to the hearing. So before the hearing, you should get a paper copy of the bundle at least 10 working days before the hearing date. Check it carefully. Make sure it contains all the evidence that has been sent. Make a note of all the particular bits of information you want the judge to take into account. The page number and where on the page, for example, second paragraph. Sketch out an opening statement and/or a summary. You'll get an email with notice of hearing instructions. At present, all hearings happen remotely. Think about how you'll access the hearing, how you'll be able to involve your child or young person if appropriate, and communicate with them during the hearing. It's worth checking whether your internet connection is stable. Is your device hands-free? Is your room quiet? Are you able to give full attention? And where possible, it's important that your child or young person has a chance to be as involved as possible or as they feel comfortable. Not surprisingly, the tribunal is very keen to hear the views of the child in whichever form is best. The hearing, do's and don'ts. Do be polite and expect formality. Unless told differently, the judge is called Madam or Sir. Be confident to quote the law. A good way to do this is, my understanding is, or I believe that may be relevant. Do give the judge time to write his or her notes. Speak slowly and understand if they ask you to stop speaking so they can catch up. Do be confident to counter anything you feel is said in error, but give your reasons. And refer to evidence whenever you can. Don't grandstand. This is not a forum to air grievances with the local authority or school or college. Don't interrupt. Even the LA does this. Don't copy them. Don't refer to evidence not in the bundle or not accepted as last-minute evidence. And don't worry. Good reasons and good manners can get you a lot of wiggle room if things don't go as planned. So the hearing's over. You don't hear straight away. Getting the decision. You should get an email with a decision within 10 working days of the hearing. If you've not got one within this time, email SENDIST and chase it. If the decision is in your favour, then the local authority must start the assessment process within 4 weeks of the decision date. So for tribunal guidance, the SEND Tribunal produces a free booklet and other guidance forms on their website. Links are available here.